will come to order. The next presenter will be Ms. Ann Yerger, Executive Director, Council of Institutional Investors. Ms. Yerger.
Good morning. I think it's still morning. Thank you very much for the opportunity to share the Council's views on the very important issues under consideration today. By way of introduction, the Council is a nonpartisan association of public, union, and corporate employee benefit plans with assets exceeding $3 trillion. Council members are responsible for safeguarding assets used to fund the retirement benefits of millions throughout the United States. Our members are quite diverse and actually include the state funds, I believe, from almost all of your states, along with corporations such as Johnson & Johnson and unions such as the AFL-CIO. So clearly, there's a wide variety of views on issues within the membership. Our members do share some very important characteristics. First, they have a very significant commitment to the domestic markets, on average investing about 60% of their portfolios in stocks and bonds of U.S. public companies. And they are long-term patient investors due to their lengthy investment horizons and heavy commitment to passive investment strategies. As an initial matter, I want to state up front that consistent with our membership-approved policies, the Council has no position on the legal issues arising from the Citizens United decision, including whether there should be limits on corporate political activity. And since we are an organization of investors, I have no position either on the appropriate role or appropriate need for limitations on activities by non-public entities. Rather, we view the issue of corporate political activity solely from the lens of an investor organization that advocates corporate governance best practices and share owner rights. Our long-standing policies reflect consensus among Council members that political and charitable contributions by public companies are important corporate governance matters warranting robust board and share owner oversight, comprehensive and accessible public disclosure, and meaningful director accountability. Corporate governance at its most fundamental is about ensuring that investors' capital is prudently used to create long-term value. Heightened scrutiny is warranted any time corporate executives may simply give away investors' money. The Council acknowledges that to date, corporate political and charitable contributions are generally immaterial in amount. However, as Professor Coffey noted, given the potential for conflicts, waste, and legal, reputational, and governance risks that may arise from corporate political and charitable contributions, enhanced oversight is particularly important. The Council believes such oversight is best addressed by directors and share owners through a combined approach focused on disclosure and board accountability. Thus, we believe Congress should consider taking steps that would facilitate a market-based, disclosure-focused approach to corporate political and charitable activity. That approach should include at least two elements. First, requiring all public companies to disclose their charitable and political contributions, as well as their board's policy for monitoring, assessing, and approving such spending. To be useful to investors, those disclosures should include amounts and recipients. They should also be readily accessible through some electronic, widely used format that facilitates comparisons and other analyses. Second, providing share owners with meaningful tools to hold directors accountable if they are disappointed with their oversight of the corporation's charitable and political activity. More specifically, all public companies should be required to first have majority voting for the uncontested election of directors, and second, provide long-term share owners the ability to include directors' candidates on management's proxy card. That's the so-called proxy access reform. I should note that the Securities and Exchange Commission is considering a proposal addressing proxy access, and the Council strongly supports this proposal. The Council also commends the House for affirming the SEC's authority in this area in the Wall Street Reform and Consumer Protection Act of 2009. I agree transparency is the best disinfectant. However, that's only half of the solution. Without basic reforms to the director election process, share owners simply will not have the tools they need to hold directors and boards accountable for their oversight performance, including their oversight of political and charitable spending. Before closing, I would like to note for the record that at this time the Council's policies do not address share owner approval of political and charitable contributions. Views are mixed within the Council membership on this issue. Some members strongly support such approval. Others have concerns, particularly regarding the workability and effectiveness of such a vote. Thank you, Mr. Chairman, for inviting me to participate, and I look forward to answering your questions.
Thank you very much, Ms. Yeager. Barrett, Assistant Professor of Law, George Mason University School of Law. Mr. Barrett.
Chairman Ken Jaworski, Ranking Member Garrett, and distinguished members of the committee, it's a privilege to testify today. I thank you for the invitation. My name is J.W. Barrett. I am a professor of law at George Mason Law School, and I am also a senior scholar in the Mercatus Center at George Mason University, where I'm a member of the Financial Markets Working Group. I also direct the Corporate Federalism Initiative, a network of scholars dedicated to studying the intersection of state and federal authority in corporate governance. The one group with the most to gain from H.R. 4537 and other bills under consideration today, including H.R. 4537, the Shareholders Protection Act of 2010, are large institutional shareholders that have unique conflicts of interest. The group that stands to suffer the most from much of the legislation under consideration today are ordinary Main Street shareholders who hold shares through their 401ks. There are two types of shareholders in American publicly traded companies. The first are retail investors, or ordinary Americans holding shares through retirement funds and 401ks. Half of all American households own stocks in this way. The other type of investor is the institutional investor, including union pension funds as well as state pension funds run by elected officials. H.R. 4537 and other legislation seeks to give those institutional investors leverage over companies for political purposes at the expense of retail investors. We have seen numerous instances where institutional shareholders use their leverage to achieve political goals, like CalPERS, the California Pension Fund, and their insistence on environmental or health policy changes that are paid in the end by ordinary shareholders. Today's legislation attempts to contort the securities laws to regulate campaign finance. In doing so, it risks limiting the ability of companies to communicate with legislators by giving special interest institutional shareholders like unions power to stop those communications. This bill does not limit union political spending in any way, I might add, and it has nothing to do with the investor protection goals of the Securities Exchange Act, other than the fact that in the end of the day, it actually harms those goals. Shareholders have two available remedies if they become dissatisfied with the performance of their companies. They can sell the shares, or they can vote for an alternative nominee. They do both with some frequency. In the rare event that political advocacy results in corruption, there's a third line of defense in place. The Audit Committee of the Board of Directors, which is independent of company management, determines that donations are inappropriate. They are required under the Foreign Corrupt Practices Act to stop them immediately. The structure of American corporate law rests the authority to manage the day-to-day affairs of the company, including decisions of how to invest the company's funds, with the Board of Directors. Putting expenditures to a shareholder vote, like the legislation today requires, is the first step toward turning shareholder votes into town hall meetings. Some shareholders may want the company to locate a new factory in their town or give away health benefits for employees without regard to whether those expenses risk bankrupting the company. Shareholders choose the Board of Directors and delegate authority to make those decisions to the board in order to avoid that very problem. Political risk poses a danger to the 401ks of ordinary Americans more now than ever before. Leaders responsible for policies that subsidize dangerous mortgage practices, for instance through Fannie Mae and Freddie Mac, now seek to expand financial regulations to generate the appearance of responsive action. The Supreme Court recently affirmed that companies have a constitutional right to advocate on behalf of their shareholders. Corporations do so particularly to protect the property rights of those shareholders from expenses associated with regulations whose costs might exceed their benefits. Many reputable companies spend money in this way. Berkshire Hathaway, for example, one of the most highly regarded companies in America, spent $3 million last year advocating for the interests of the company and its shareholders. Today's bill purports to redefine state corporate law to make unvoted expenditures a violation of the company's fiduciary duty. This is a serious misunderstanding of the structure of corporate law. As Justice Powell wrote, no principle of corporate law and practice is more firmly established than a state's authority to regulate domestic corporations, including the authority to define the voting rights of shareholders. The Shareholder Protection Act of 2010 has nothing to do with reforming financial regulation in response to the financial crisis, and indeed is a distraction from that vital work. It risks giving powerful institutions, such as pension funds and state-elected treasurers, dangerous leverage over the retirement savings of ordinary Americans. To call H.R. 4537 a Shareholder Protection Act is fundamentally misleading. I thank you for the opportunity to testify, and I look forward to answering your questions.
Thank you very much, Professor. And next, we have Ms. Nell Minow, editor and co-founder of the Corporate Library. Ms. Minow, I understand you're the daughter of Newton Minow, is that correct?
Yes, I am.
Oh, congratulations. Quite a famous fellow.
He's also the world's best father.
Ah, great.
Thank you very much, Mr. Chairman and members of the committee. It's an honor to be back in this room to talk with you about one of my favorite subjects, corporate governance. I want to associate myself with the remarks of the first three panelists in particular, and so I'm not going to reiterate their points. I'm just going to move over them quickly so that we can get to the question part. But I think we can all agree that if the bedrock principle here in the United States is freedom of speech. We're all in favor of freedom of speech. We're all in favor of the marketplace of ideas and of allowing even bad ideas in and countering them with better ideas. But we cannot let the marketplace of ideas be tainted by that other marketplace, the one that involves actual money. And I think that that's what's happening here. I'm a little surprised by Professor Verrett, aside from the fact that he's factually wrong on a number of his assertions. 401k investors, for example, invest largely through institutional investors and don't do individual stock picks. But I'm a little surprised because I thought that he understood that markets run on information, and what we're really about here is getting that information out there. The conflict of interest is not at the shareholder level. It's definitely at the executive level. Executives are the ones who spend corporate money hiding it through intermediaries to influence the political outcomes in a way that is even contrary to their expressed views. We need to clean that up if, in fact, as the court says, corporations are assemblages of individuals with First Amendment rights. Let's make sure that the corporate positions reflect the views of those individuals. I really particularly object to his point that apparently shareholders are smart enough to buy the stock and to vote the stock, but they're not smart enough to vote the stock intelligently. I think the whole idea of shareholder rights is that shareholders will, in aggregate, make the right decision, and when they don't, they bear the consequences. That's what markets are all about. So the problem, as always under a capitalist system, is agency costs. How do we give corporate managers enough authority to run the company in a way that is sustainable over the long term without giving them so much that they appropriate corporate funds for their own ends? Well, the secret is, of course, better disclosure. If we had a better idea of what they were doing, then perhaps I would be able to tell you exactly how much money the insurance industry is spending to stop healthcare reform instead of saying it's between $10 and $20 million. I don't know. How do I not know? Because it's not disclosed. Problem number one is the lack of disclosure to the current and potential investors in the company. Problem number two, as Ann Yerger said, is that even if shareholders know how their money is being spent and what positions it's being used to support, there's no way for them to respond effectively to provide necessary direction. I always love explaining to people who know better than anyone else in the world what an election means, that in the corporate world, no one runs against you, and management nominates the candidates and counts the votes. Not only that, but if you only get one vote, you get elected. We currently have over 80 directors serving, even though a majority of the shareholders voted against them. We've got to have a better system than that. We must require a majority vote and give shareholders access to the proxy to run their own candidates. The third problem, and the one I really want to focus on, is the problem of intermediaries. It's not enough that corporations must disclose every penny that they spend on political contributions, lobbying, ads, etc. We have to get them to disclose what they funnel through intermediaries, whether they're the Chamber of Commerce, which has been completely co-opted by the executives to the detriment of business, or these fake groups that are called something like Citizens for a Better Tomorrow. The Chamber of Commerce, which recently was found to have overstated its membership by 900%, has been particularly susceptible to this kind of manipulation. They now have, of course, only 300,000 members, not the 3 million they'd previously trumpeted, but their tax filings show that just 19 donors contributed 1/3 of their income. We need to find out where that money is coming from and where it is going and who it benefits. The fourth problem is, and this is the one that I think is most important, is once shareholders have the information, do they have the right and the opportunity and the obligation to act on it? Shareholders, institutional shareholders, of course, are fiduciaries, the strictest standard under our legal system. I think that's intended to address the conflicts of interest that may exist. that Professor Verrett refers to, but we need to make sure, I would really love to see this committee call in Fidelity, Vanguard, et cetera, and ask them, how do you vote on these issues? What do you look for? Why aren't you doing a better job? Finally, the fifth problem is that political elections, as you know, are too expensive in this country. I think we need to work on that side of it, too. I urge the members of this committee to give careful consideration to the Fair Elections Act and to making free television time available, because, frankly, if that was available, politics would not be so expensive, and we wouldn't have this problem to begin with. Thank you again for allowing me to comment, and I look forward to your questions.
Thank you very much, Ms. Minow. Next, we'll have Professor Michael Klausner, Nancy and Charles Munger, Professor of Business and Professor of Law, Stanford Law School. Professor Klausner.
Thank you, Chairman Kanjorski, members of the committee. I, too, agree with much of the first three speakers and Ms. Minow as well, so I'll be brief. In Citizens United, the Supreme Court recognized that its decision left open the question of how the corporate governance regime would address political advocacy by corporations. The court suggested that concern over management control of political expenditures could be, quote, corrected by shareholders through the procedures of corporate democracy. The court further stated that the remedy is not to restrict speech, but to consider and explore other regulatory mechanisms, close quote. So that's what we're doing today. The threshold question is, what can shareholders do under the current governance regime if they'd like to influence management's use of corporate funds for political activities? And the answer is not much. The only potential tool available to shareholders, as Professor Verrett said, is their right to vote annually to nominate for nominees to the board of directors. That mechanism, however, is poorly designed for the purposes of controlling political expenditures. It doesn't allow shareholders to exert any sort of advance power, nor does it allow shareholders to vote out boards of directors, as Ms. Minow said. So the vote for nominees to the board is not going to be effective in this realm, in my view. The other potential response, also referred to by Professor Verrett, is that shareholders can sell their shares. That response, however, won't influence management's political expenditures, and in fact, it barely amounts to self-expression. Management won't even know the shares have been sold. They'll be bought by other investors who don't know of or aren't bothered by the political expenditures. Unless the political expenditure is significantly bad for business, there'll be no effect on the company's share price and therefore no influence on management before or after the fact of their political expenditure. Now, if a political expenditure is materially bad for business, then the share price will decline as a result of normal share trading, regardless of whether there are politically motivated stock sales. So, in sum, the current system of voting for boards of directors and selling shares isn't really a response to the political expenditure question. The basic problem is that the current system is not designed to give shareholders a direct voice in management decision-making, nor should it be. The assumption of the system is, first, that shareholders essentially have uniform interests in having management maximize the return on their investment, and second, that shareholders lack the expertise to manage the company. Valid assumptions in the context of business decisions. But they don't apply in the context of political expenditures. Shareholders are not uniform in their political views, and there's no reason to defer to management on this dimension, which has little to do with expertise in running the company. Now, the fact that shareholders lack effective means of controlling political expenditures doesn't mean that they'll do nothing. To the contrary, they could well decide, I expect they would, to use the annual vote for board nominees as a means of expressing dissatisfaction, even though doing so will not result in displacing the board. This use of the shareholder vote would undermine the signal that vote could signal with respect, the signal of that vote with respect to the quality of management and its business decisions. I therefore think not only is the shareholder vote inadequate, but it actually is a poor vehicle through which to try to control political expenditures. So what do I do think could happen, or what should this committee consider? I propose the following: that corporations be required to let shareholders vote annually on whether they want their company to exercise the rights Citizens United gave to them. Managers who seek shareholder approval of political expenditures would use this opportunity to explain the expenditures they intend to make, how those expenditures would be in the shareholders' interest, and what the cost would be. It need not be a line item disclosure, just a description of the types of expenditures management anticipates. The vote would be separate from the vote for board nominees. Therefore, shareholders would be able to express their views on politics separately from their views on how well management is doing at running the company. The mechanism isn't perfect, but I think it's an improvement over what we have now that Citizens United has been decided. Thank you, and I look forward to your questions.
Thank you, Professor. And finally, we'll hear from Mr. Jan Barron, partner, Wiley Ryan. Mr. Barron.
Thank you, Mr. Chairman, and thank you for your excellent Polish pronunciation of my name. Can you hear me? Is this on? Thank you. Thank you, Mr. Chairman, and again, I want to note a thanks for the correct Polish pronunciation of my name. I am Jan Barron. I am a partner at the Washington, D.C. law firm of Wiley Ryan, LLP, and I head the firm's election law and government ethics group. I am here today in my purely personal capacity, even though I was involved in the Citizens United case through the submission of an amicus brief. I am not representing any party to that case or any client of my firm. I would like to touch on three subjects in summarizing my prepared comments, which were submitted to the subcommittee. First, I'd like to just spend a moment to make sure we understand the scope of what the Supreme Court did. Second, to comment on some of the constitutional ramifications of that decision in the context of what you're considering here in this subcommittee. And then third, to touch on some practical concerns I would have that I'm sure you will want to take in mind when you undertake your legislative drafting. In terms of the Citizens United case, the technical conclusion of the court was that the First Amendment does not allow Congress to prohibit corporations and presumably unions with respect to the content of certain public advertising. And that content involves what is called express advocacy or electioneering communications. Until the decision, federal law and the law in approximately 24 states prohibited corporations from financing public advertising that says vote for or against a named candidate. Up until the Citizens United case, there were many other forms of corporate finance advertising, including political advertising, that were permitted and, in fact, protected under the First Amendment, including so-called issue advertising, discussion of public officials with respect to public issues and legislation. And, in fact, 2 days before the Citizens United case, there was a special election in the state of or Commonwealth of Massachusetts. And in that election, which predated Citizens United, under existing law, there was approximately $4.5 million in advertising financed by corporations and unions and other forms of groups with respect to that election. So the technical consequence of Citizens United is that corporations can now be unburdened with any content regulation as to what they say, independently of any candidate or political party, and they can do so at any time. They cannot be limited in their pre-election communications to the public. Having made that conclusion, this subcommittee in Congress has a challenge of addressing what forms of regulations it may want to implement in light of Citizens United. Obviously, I've heard a great deal of discussion about corporate governance and corporate law principles, which is what I assume is the typical jurisdiction of this committee. But when you legislate now, you are legislating in an area of First Amendment rights. And you don't have as free a hand, assuming you did before. One of the principles in First Amendment jurisprudence is that political speakers must be treated equally. And this has been evidence in numerous Supreme Court cases involving, for example, First Amendment exercise of picketing and other forms of expression. There were laws in Illinois at one time that prohibited certain types of picketing except by labor unions. And the Supreme Court in the Mosley case said, well, there's no reason to distinguish between these types of activities between unions and corporations and other organizations. And just last month, the Colorado Supreme Court struck down a state law that imposed contribution prohibitions and limitations on labor unions if they had a contract with the state, but did not do so with respect to private corporations or other types of entities that had government contracts. And the reason that they struck it down is that in these types of cases, the government has an obligation, when questioned in court, to come forward and explain why different speakers, different participants in the political process exercising First Amendment rights are being treated differently. And you have to demonstrate a compelling governmental interest in justifying the disparate treatment. So how does that affect you and this legislative issue that you are addressing? Well, if you are going to require shareholder voting because you want to have the participants in a corporation make this type of decision, why will that not be true of other speakers spending money, including labor unions? Will their members now approve any expense over $10,000? And what about other types of incorporated entities, trade associations? Will a trade association require the vote of its members before it spends more than $10,000? What about groups like the National Rifle Association, the Sierra Club? And if they're not going to be required to, quote, approve this type of an expense, what is the reason that you are requiring business corporations to do that? There's also other types of discriminatory effects that you will have to be mindful of. I know that Congressman Capuano's proposed legislation that's currently drafted, I've not seen any of your revisions, sir, but it requires shareholder votes for expenses over $10,000, except for media corporations. There's an exception for media corporations. So there has to be an explanation. Why are we treating public media corporations differently than other types of public corporations? And that presents a big problem because the Supreme Court in Citizens United noted the discrepancy of treatment of public media corporations and said that really wasn't fair. All corporations should have the same rights that media corporations have. And in practical terms, some media corporations are actually subsidized by subsidiaries that aren't media corporations. I'm thinking of the Washington Post Company. The newspaper is a money-losing proposition, but the company is quite profitable, mainly because of Kaplan Educational Services. So one can say that's a media company, but in fact, it's being subsidized by non-media corporate activity. And finally, as noted in my written testimony, that you will have to confront some very practical implications in anything that you propose, including proposals by other committees or other legislation that may not be handled here. For example, I note the question of what's going to happen to foreign corporations. There's a suggestion elsewhere to treat corporations that are more than 20% owned by foreign nationals, however that's defined, to be a foreign company, and therefore they cannot make any expenditures. That presents some unique issues, but it also runs into some of the things you're considering. If you require public corporations to have a vote of stockholders, what does that mean for a foreigner who owns stock in one of these corporations? Are you requiring them to vote on this, or are you going to prohibit them from voting on these types of issues because, after all, they're foreigners? And Separately, there's the issue of, well, what does make a foreign company? 20% stock ownership? Or what about a company whose revenues from foreign sales well exceeds 20% of all their revenues? That's foreign money coming in here to a corporation. Does that make that corporation foreign in the sense that it is now benefiting from foreign financing, which theoretically could be used here in the United States in terms of political expression? Thank you for this opportunity, and I look forward to your questions.
Thank you very much, Mr. Barron. I'll take my few moments, and then we'll hear from the experts in the committee. First of all, it strikes me that we should be considering a resolution to establish the United Corporations of America, because isn't that the path we're really going on? We're trying to make corporations and other entities like that so human as to be true, complete citizens of the United States. It sounds far-fetched, but I'm not sure we're not running down a path that won't become very popular in a short period of time to call for and convene another constitutional convention in the United States to re-examine the First Amendment and the rights attendant thereto. And I think we're on that track ever since Sullivan versus New York Times, to tell you the truth, and that whole course of conduct that we're in. And it somewhat frightens me. And just to take it out of the realm of humor in terms of establishing a constitutional convention, maybe that should be serious. But, in Pennsylvania, at the turn of the century, we had a very unique thing that the three industries of Pennsylvania, the railroad, the steel industry, and the mining industry, actually had reserved seats in the state Senate of Pennsylvania so that they could participate right on the floor with the senators, so they wouldn't get too far away from the intended principles of capital. And it always struck me that that's about as far as the country, and certainly Pennsylvania, had gone, and then we swung back to the progressive era of Roosevelt and changed some of those things. But we seem to be on that same course right now. And I just did, and then we ran across this, incidentally, at this committee most recently, of how to get our arms around rating agencies with their constitutional protection under the First Amendment, and what do you do, and what the effect is, and how do you regulate them. I'm not at all sure that, if I had my own druthers, I would view the First Amendment to the Constitution in terms of free speech as not being corporate free speech. That if you want the protection of free speech, be a single entity. Once you start getting in a conglomerate, you should lose those rights. But we've lost that battle. Now we're on to corporations, and I happen to agree with you, Professor, on if 21% of a corporation is foreignly owned as compared to 19%. Yeah. And who should participate? I'm more worried about the amount of monies involved and the effect of that money on elections. Having participated in 13 or 14 primary and general elections in my term in Congress, I've seen what money can do in campaigns, and it seems to pollute them every year more and more. And sometimes humorously on the floor now we comment that really it would be much better if everybody just announced that they're no longer going to take a salary or take an office allowance, but that they would have their sponsors pick that up. And you could go to your constituents and say, I'm not costing you anything to cast your representative vote in Congress because I represent United States Steel. And they pay my salary, and and everybody go out and get their corporate sponsor. And I'm sure some segment of the American population may think that's a great cost savings. I hope not, but I'm afraid that may be the truth. Where do you see this, and maybe I'll start with you, Professor Goff, where do you see this ultimately ending? I know your presentation got us to how to handle immediately using the governance provisions, but do you think we ought to go beyond that in addressing this issue and think about going to the basis of the Constitution itself and whether or not we've lost control of that definition?
I would hesitate to encourage anyone to convene a constitutional convention. There are so many different issues here. The rating agencies are one issue. I think courts can still handle that. There is this area where we're told corporations have speech, but the Supreme Court is also telling us that shareholders have full control over limiting, curbing, and focusing that speech. And I think that should play out for a bit. I think you should think about a range of options for shareholders, whether it's an annual vote, whether it's bylaw votes, whether it's referendums, giving them all the possible mechanisms to control their own organization. I think that's the least drastic means. And I would suggest we approach this by looking for the least restrictive alternative, and I think that's enabling self-regulation. If self-regulation fails, and we may decide that in 4 or 5 years, then we can come to the Constitutional Convention. But I'm not sure that we got the same people that we had when Madison, Hamilton, and the Founding Fathers were putting this together, and I think that this would be also intensely lobbied. So I would first give the chance for self-regulation to work by empowering shareholders and by prodding the SEC, which I'm a great admirer, but they're very busy. And they need to respond to this new revolution. Citizens United is a revolution, and they have to think about how they should reform and revise their own disclosure medium to give shareholders more information. Only then will voting work. Voting works when there's full information. So I'm suggesting self-regulation first, and maybe ultimately you'll be right, and we have to have this convention, but I wouldn't rush there.
No, I'm afraid I agree with you in terms of we probably would lose a good portion of the Bill of Rights if we convened a convention. The price would be extraordinary. But it looks like we're headed down that path. Do any of you as Constitution scholars see, has the court gone to its extreme with this thought process, or are they going to go beyond this and continue to go beyond this and just push us to a corporate society?
Gee, I think it depends a lot on who's on the court.
Well,
we're going to have transitions coming. I would think that the court has taken a strong position, but it's also left open a lot of room for self-regulation and for regulation that enhances the power of shareholders to curb and control the corporation. And I think that's the area that can be most exploited in the short run.
How do you handle Mr. Barron's problem with the ownership problem?
You know, I did hear, well, there's Mr. Barron and Mr. Verrett, and they had different views, but they were somewhat similar. I don't believe there's a fundamental conflict here between institutional investors and retail shareholders. There may be in some other areas like securities litigation, but I don't think there is here. And in terms of Mr. Barron's problem about foreign shareholders, I don't think there's any danger about this bill being under-inclusive because it covers only publicly held corporations. That's where we have the problem of dispersed ownership, where there are tens of thousands of shareholders and management that is effectively immune from shareholder control. When you look at privately held corporations, there are powerful shareholders there, and they can find their own ways to control managers. So I would start with the publicly held corporation, where Congress has always directed the securities laws at the publicly held corporation. And I don't think there is any danger of a statute being found unconstitutional because it's under-inclusive. Others may want to comment.
How do you handle the hidden ownership question of whether the ownership is in trusts or other devices that really doesn't readily disclose who the owners are? I mean, how do we know that, in fact, China isn't a participant in a trust held in one of our major banks?
I think you can't handle every problem at the first crack of the bat. It could well be that there are conflicts that you will find among institutional investors, but institutional investors probably own over 70% of our largest companies. And if we feel that there are conflicts there influencing their voting, Congress can come back and give the beneficiaries greater control of the institutions. But I would start with the manageable problem of giving the shareholders of the company a greater say in this process, because right now they don't know what's going on.
Mr. Castle, I exceeded my time, and I'm going to get your question.
Thank you, Mr. Chairman. Mr. Barron, you stated in your testimony, and I think I wrote it down, I think you said that this case applies to corporations, I think you said presumably unions too. And I've not read it, and I'm not an expert on it anyhow, but does anyone disagree here on the panel that it applies to unions as well as to corporations? Sampson?
Mr. Castle, I think the regulator, the Federal Election Commission, has determined how it's going to enforce the law, and it's going to enforce the law in the same way against labor unions as corporations. I mean, the labor unions will be free to make independent expenditures from labor funds.
Well, in the, I don't know if this hearing is about just Mr. Capuano's bill or not, but it's been referred to, and it refers to shareholder protection and deals with just corporations. Would you not agree that we need to deal with the union issue as well?
I think the union issue is somewhat different. First, with respect to disclosure. One of the problems in the corporate area is most of the money is not disclosed. Most of the money unions use in politics is disclosed. Second is, I don't think anybody, even Mr. Capuano's bill, is looking that the beneficial shareholders actually have a vote. But when you have a large number of institutional shareholders and others who are representing the interests of those beneficial shareholders, the millions of Americans out there who hold stock beneficially, that they should be required to act in this area.
Well, I'm not sure I agree with you. I mean, the mere fact it's disclosed may not be sufficient. I mean, should the various union members be given the right to vote on whether or not the actual expenditures are being made? Why wouldn't the same rules apply? I mean, there are different circumstances of stockholders and union members, but why wouldn't the same rules apply?
I think the issue would be how to define those rules. Who would have
I agree with that.
to vote?
May I respond to that, please? There are several differences, but the main difference is that, as I discussed in my testimony, we do not have a robust system for electing corporate directors. We do have a very robust system for electing representatives in these other kinds of entities. I'm not saying that we shouldn't have rules that apply to them and disclosure rules, but the fact is that union members can actually change their management if they don't like the political positions that they're taking. I'm open to the idea.
Let me interrupt you. I mean, they can't change their. I mean, you can change the board of directors too. They can't change their officials
Actually,
that
you can't
easily.
change
They
the board
could
of
change
directors.
them.
That's my point.
on the next
80
election.
directors are currently serving on public companies in this country, even though a majority of the shareholders voted against them. It's almost impossible. It's less than a fraction of 1% of the cases where.
That doesn't make your earlier statement correct, though. Your earlier statement was that they could change the people running the union. They can't do that until there's an election or something.
Until there's an election, but then they can. But they actually can when that happens. There are also several, they're different kind of entities. They're organized differently. I'm not saying that shouldn't be addressed, but we should understand their differences as we address them.
Okay.
Representative Castle, if I could add to that as well, and
Yes,
just as in
Professor.
counter to the view that elections aren't contested for boards of directors. Last year, at 59 companies, dissidents were victorious in contested elections, dissidents against the incumbents.
Thank you.
I did say a
Wait,
fraction
wait,
of a
wait a minute.
percentage, and that is a fraction of a percentage.
Thank you. Professor Verrett, you indicated that who has the most to gain by all this is the large institutional stockholders, and the ordinary retail investors might have the least to gain. I'm a little bit concerned about that as well. I mean, talking about the corporate structures now, in a broad sense, in that you may have any one of us in the room owns 100 shares of something, and then you have those who own 20,000 shares or something or whatever it may be, and who's really going to benefit from this and who is not in terms of making decisions. Can you expand on that a little bit?
Yeah, I would offer that retail shareholders who own mostly through 401ks, whether through mutual funds or indirectly in shares, don't have the time to vote their shares the way that a union pension fund would, or the way that a state pension fund would. They don't have the incentive to do so the way that those large institutions do, and they don't have the time and the resources. But we've seen some political conflicts of interest from some of the large institutional shareholders. And for instance, Mr. Angelides, when he was treasurer of the state of California, a very dedicated public servant, but certainly a political figure, as everybody would agree, said, look, CalPERS has very strong policies about environmental regulation and about health care, and we're going to use our shareholder power to see those through. Policies we can't get through Washington, we're going to use our shareholder powers to get them. Now, those might be very important issues, but I would take issue with the fact, with the instance of using federal securities laws and using ownership in companies to deal with those policy issues, because I don't think ordinary investors through their 401ks want to pay for that.
But if I may just clarify, ordinary investors who are indeed generally investing through 401ks are investing through mutual fund companies, institutional investors who have a fiduciary duty to vote on behalf of those individuals. So those individuals don't even have the right to vote those shares, but the mutual fund company does have the right and the responsibility. And those votes, I might add, are publicly disclosed. So I actually strongly disagree with your assertion there.
Well, I don't disagree with respect to mutual funds. In fact, my concern is not really with mutual funds today. It's more with the institutions that have demonstrated political interests.
They are indeed a minority of the institutional ownership.
And I disagree with your characterization of those interests as political interests. Are you saying that there is no legitimate interest of a fiduciary investor in the environmental policies of the portfolio companies? Of course, it's a completely legitimate interest, and you're making a completely false dichotomy.
I'm suggesting that fiduciary law is not sufficient to deal with these conflicts of interest with respect to state pension funds and union pension funds. Yes, I am suggesting that.
Can I just clarify one thing?
Wait a minute. Let me hold everything. Mr. Chairman, how are we doing time-wise here?
We're down to about 2.5 minutes.
On the vote?
Yep.
On the floor. I think we're going to have to suspend at this point.
Yes.
I yield back.
If I may call the attention of the panel, Professor Krosner and Mr. Barron have a conflict that require them to leave by 12:30. We're faced with 6 votes now on the floor, and that would necessitate us being away until about 12:30. We will return. We ask the rest of the panel to remain at that time, and the next examiner will be Mr. Capuano. What? Yeah, and we're going to recess now, and you'll be first up. And if you're first back, take the chair, start, and convene. Okay. This committee will stand in recess.